still completed the crime of conspiracy because the crime is the agreement and then taking an overt act in furtherance of it. It's not the completion. It's not the completion of the crime. The crime is the agreement, and the case law on that is clear. And so even if the jury is entitled to see those elements, which they will in this case because they've been charged with those separate crimes as well, they don't have to find those elements. They don't have to find a single element of those crimes to find the crime of conspiracy. I found no case law to suggest that's the case. And I don't believe there is any case law to suggest that because the crime is the agreement and the overt act. In terms of, Mr. Thomas raised the issue of when does it end? Well, and the court pointed out there can be ongoing conspiracies. And we do believe that the evidence here is going to show that it ended when Social Security stopped paying out the money that was being stolen. And we believe, and so the conspiracy doesn't necessarily end when one of the crimes is completed. If there's multiple crimes, it ends when the whole conspiracy ends. And I don't think that's confusing. I don't think a jury's going to find that confusing. And so again, Your Honor, I go back to the point that the law isn't unfair because it's bad for the defendant. That doesn't mean it's unfair. The law is not unfair because it's not in the defendant's favor. No crime is in the defendant's favor. And so I take issue with that agreement that this is fundamentally unfair. I don't believe this is fundamentally unfair. I think these are charges based on the evidence provided to the grand jury. They didn't have a problem with it. They found it. And so if they can find it, I think we can put it in front of the pettit jury, the trial jury.
Mr. Wood, I do have a few more questions on that. And I'll just let you know, before the motion was filed, I've looked at these two counts a lot of times because I have not determined whether or not they're correct or incorrect, but I will say I haven't seen charges that had multiple crimes that were unrelated like that in a single count. And thinking in terms of going forward, my concerns have been two. Number one, how do you instruct a jury with a jury instruction? And maybe we'd start there. Do you believe a jury instruction would require a definition of all elements of both offenses if you're going to tell a jury they conspired to commit these two crimes? The way the indictment is written, it's in the conjunctive using the word and, conspiracy to commit first-degree murder and grand theft. So that tells me the jury's got to find both of them, not one or the other, is the way it's written. And so do you think within a jury instruction you've got to say, and here's what a first-degree murder is, and here's what a grand theft is, and is that all part of, now we're getting to a very, I can see a very large and cumbersome jury verdict form or instruction on how do you find count one?
I have seen no case law or authority that says we have to provide the elements of the underlying crime to the jury. If it's out there, then it's out there. But I've seen, in my research on this issue, I've never seen any authority that states we have to do that. And I think the rationale behind that is those underlying crimes are not the crime. They're already being charged with the murder and the grand theft separately. At least Mrs. Daybell is charged with the grand theft separately. And so the jury will have those elements already anyway in this case. So if that is a concern for the court, I think it's already taken care of because the jury's going to see the elements of those crimes when they have to decide on the murder charges and the grand theft charges. I actually think that we are confusing the issue if you start giving the elements of the underlying crimes in a conspiracy instruction, because the conspiracy is the crime, the agreement is the crime. We've been given the jury instructions from the Supreme Court, and nothing in there says anything about the listing out the elements of the underlying crimes.
Okay, and I appreciate your response. And the next issue I had is back to what Mr. Thomas brought up also under the statute that sets out the punishment for conspiracy. It's whatever the punishment is, as it states, for the crime or offenses they combine to commit. So if there were a guilty verdict returned on count 1 and or count 3, what do you believe is the statutory required maximum penalties for that offense, where you've got one offense that's only a 14-year maximum, one is up to life in prison or death? Do you pick the higher one? Do you pick the lower one? Does it matter? Do you pick both? Could they run consecutive? Those are questions I have also with these two separate different offenses, and going to what would a punishment be then if you got there?
Your Honor, I don't think it's that confusing. I think they're punishable by the underlying sentences. So they can receive the death penalty for conspiracy to commit murder. And I think that's well established. And I think in this specific case, if the jury is to find them guilty here, the ultimate punishment for that is the death penalty. And I think when you just look at it in a common sense approach, that lower sentence is swallowed up in the higher sentence anyway. And so I don't find that to be an issue. I think the statute is clear. I think the statute even, it uses the plural with the word offenses as well. So I think it already contemplates that. I think whatever the higher one is the one that controls.
Okay, I appreciate your response on that question as well.
Any other questions?
That's the only questions I have at this point.
I would just end, again, Your Honor, this is not, we disagree that this is confusing. And without going into the grand jury proceedings, the grand jury didn't have a problem with it. I don't think a jury will, a trial jury will have a problem with it. Because again, if you really break it down to what the crime is, it's not that confusing. The crime is that they agreed to murder someone and steal money linked to that person. And the crime is the agreement and an overt act. And as long as we establish that, then the jury can make the finding either guilty or not guilty. And I think when we start talking about introducing all the other elements, I don't know that there's any legal rationale or authority that provides for that. Again, I haven't found any. Upon receiving, I would note that the defense hasn't given any authority for that. And when I received their brief, we researched this before we ever put this in front of a grand jury, researched this issue, and then when we received their brief, we went back and researched again. I haven't found any authority that says that's the case, that we need to do that. And so, based on that, we would ask the court to deny the motion. Thank you.
All right, thank you, Mr. Wood. Mr. Thomas, would you like to present any rebuttal argument?
All right, before we hear the rebuttal arguments, we're going to take a quick break. Don't go anywhere. This is Court TV Live. We'll get back to the courtroom and see more of Cult Mom in just a moment.
Emily Noble is reported missing a day after celebrating her 52nd birthday.
Her body was staged to appear as though it was a suicide. That was absolutely not the case. Emily's husband was arrested. 2 different counts of murder.
The question is, was she murdered or was it suicide?
This was clearly a homicide based on the injuries that were sustained.
Our cameras taking you inside the courtroom as this dramatic case unfolds.
The staged suicide murder trial. Live coverage today on Court TV.
Live. Welcome back to Court TV Live. I'm Julie Grant. Thank you for being with us on this Tuesday. We are in Idaho watching Lori Vallow Daybell in court as her attorney is arguing some various motions with the state ahead of her trial. We know she's going to be joined at trial with her husband, Chad Daybell. He is not in court today, but she's got something around her ring finger. Maybe it seems like it's something homemade, maybe to signal that they are married. Maybe she's unable to wear her jewelry in the jail. Who knows? But keep an eye out out for that as you watch her. She's also been seen looking almost like she's kind of smirking at certain points, or I've seen some reaction on Twitter saying it almost looks like she's trying to hold back laughter. Not sure why. This is serious stuff. She's accused of murdering her kids and her husband's ex-wife. She's accused of conspiring in all of these situations with Chad Daybell and with her brother, Alex Cox, who is deceased. Let's go back in and watch some more together now.
Just a few points, Judge. I'm a little bit concerned that the state is indicating that they researched this issue prior to presenting it to the grand jury. So I've never done a grand jury. Okay, I was a prosecutor for a few years in Bingham County, but I never did a grand jury. And so I'm not really familiar, and as are most attorneys, not really familiar with the process of the grand jury. But my understanding of a grand jury is that you present them with evidence, they go back, they deliberate, they decide what they want to charge it with, and then they come back to the prosecutor and say, these are the charges we're willing to commit, to indict this person on. What Mr. Wood is intimating, I think, is that they decided what the charges were going to be. They presented the document to the grand jury and asked the grand jury to just sign off on it. And so I'm not sure that that's appropriate. I'm not sure that that's the way it should be, and I don't know, and I probably will never know, because the grand jury deliberations are secret, and I'm not privy to those deliberations. But that's one thing that I kind of raised concerns with me, is that perhaps this grand jury was led down a path that they weren't prepared to sign off on. If I'm confused, if the court is confused with counts 1 and counts 3, I don't know what the grand jury would think. I'm assuming that they too may be, at least 1 or 2 of them may have been confused. The second thing I have is that, the state is relying upon this Fowork versus United States, a 1919 case, where it indicates, and they quote it, the conspiracy is the crime, and that is one, however diverse its objects. When you read the actual opinion, it's a very short 6-page opinion, well written, but you can tell that it's very political. It's a very political opinion regarding the war that we were about to go into, and there were issues there. And so I think that the language that they took out of there, perhaps not taken out of context, but we need to look at it in what the surrounding circumstances were at the time. I mean, we were about to go to war. The person that they were filing this charge against was the person that owned a newspaper in Missouri, and he was writing things that were bad for the war effort. And the Supreme Court of the United States, I think, latched onto that. And so I think we should take that case and that particular citation that they're heavily relying upon with a grain of salt, or at least I would ask the court to review that case, and I'm sure it will. I'm sure it had that all in mind, and maybe it has already, but I would just, I lay concern upon that, upon the state relying upon that particular case and upon that particular statement in that case where they're relying so heavily upon that. Other than that, Your Honor, I have no objections, or I have nothing further.
Okay, thank you for the argument, Mr. Thomas. So in this particular motion, then the court will also take that matter under advisement, do some additional research and review your briefings, and consider the arguments presented here today. The court will issue a written decision on the second motion as well. So I believe that concludes the proceedings for this morning. Mr. Thomas, Mr. Archibald, is there anything further from the defense today?
We have a matter to take up with the court under seal. We don't have anything more in public.
Okay, we'll take that up after. And Mr. Wood, anything further today from the state?
No, thank you.
All right, if everyone will give me just a brief moment, I want to consult with the bailiff, and then we'll conclude the hearing. All right, at this time, if everyone can remain seated, we're going to have the defendant taken from the courtroom, along with counsel can go with her if you'd like, and then we'll conclude the hearing. So once that's complete, I'll advise the audience when you're allowed to get up and leave. So we can go ahead and go off the record at this point. And I appreciate everyone's consideration.
All right, did you see it there? Did you see her hand? Let me bring in now Court TV legal correspondent Chanley Painter. We were talking about it off camera a moment ago. And Chanley, you have a theory of what that might be around her ring finger.
Yeah, we noticed that first thing this morning. It could be like, I know we're women, we wear these hair bands, right?
Yes.
Like a ponytail holder. Maybe it's some.
Does your cat love to bat it around?
Yes,
Mine does
like
too. Yes,
chew
the ones
them,
that are like a, yes. I know what you mean. Yes, they all go into the refrigerator.
Rocky, your cat, so cute. But yeah, it kind of reminds me of something like that because I don't know if she can have her actual jewelry and whatnot in the jail.
Right.
So what a statement she's making and she was holding her hand up earlier in the hearing so our cameras could pick it up. So interesting.
Was that a sign to Chad? I know Ted Rollins thinks so.
Yeah.
You and I think so. Tweet us. Let us know what you think because that looked homemade, as you said, something homemade, and she made it very apparent during the hearing. So, Chanley, the big day today came with no decisions yet, huh?
Right, I know. It's all this buildup, and then he's going to take it under advisement. There were 3 motions the defense put forth. The first one was pretty simple and actually wasn't even objected to by the prosecution. It was that motion for continuing objections, those federal constitutional protections, a standard motion, as you know, Julie. The judge ultimately just said, absolutely, that is granted.
Sure.
And then the next 2, of course, had to do with that grand jury indictment. So this is something we probably would have heard over a year ago after she was indicted. They would be challenging that. But because her case was put on hold for over a year because of her competency, we're just now hearing these motions. The defense argued the first one about remanding it for the aggravating factors of the death penalty. They wanted the grand jury to find probable cause for those aggravating factors to make sure she qualified for them, but that was taken under advisement, Julie. And then secondly, remanding the grand jury indictment because the defense wants each crime to have its separate counts. So they're arguing over whether or not conspiracy counts can involve multiple crimes in an indictment. They don't want to confuse a jury. So that's taken under advisement as well.
Right. And we do have, you mentioned the aggravating factors. We pulled them, we have them. We can show them to you on the screen so you know this is what we're looking at because we know the state is going for the death penalty.
Right.
You've reported this, Chanley. We know that the state is going to pursue the death penalty against her and her husband. And if they get those convictions, and one thing I like that Rob Wood said on the record today for anybody watching this, it really clarified that even a conspiracy conviction in Idaho would be grounds for the death penalty. They can seek it. So this is what the defense is challenging here, what Chanley mentioned. These are the various aggravating factors here being alleged by the state. And so they want it going back to the grand jury here. And so and they want everything going back, the whole indictment and the aggravating factors consider it again. And I remember you talking to us way back when about why in Idaho the state went the grand jury route rather than indicting, which they could do. Tell us again, please.
It was strategic, of course. You remember when we had the preliminary hearing for Chad Daybell, oh gosh, 2 years ago now, Julie,
Right.
and it was for the concealment of evidence because, you know, remains found in the backyard. No murder charges yet, but what we learned during that several days of the hearing really revealing as to prosecutors' evidence. Well, this time, like you said, they decided to indict instead of doing a preliminary hearing under Idaho law. So if you go to a grand jury, which is super secretive, nobody knows except those grand jurors, and they choose to indict, you don't have a preliminary hearing, so all the evidence is not public. So that's why they're trying to protect this. And even in the hearing this morning, they said they had another motion that was under seal. So even still today, a lot of the filings and pleadings in the case are under seal.
Oh, wow. That's important to know as well. Curious, any reason you would think the state would want all of that under seal at this point?
Right, well, this was the defense. It was a motion from defense. He said
from
that was
them.
under seal. And I see this a lot in Chad Daybell's case file as well online, even some motions filed under seal when he filed to disqualify the prosecutors. Again, that was under seal. So it's just interesting strategy, but there was a protective order put in place by the judge several months ago. So that may be why, too, just to try to prevent more pretrial publicity leading up to the trial. It's only a few months away, Julie.
Right.
As of right now.
That's the truth. January, so that'll be here before we know it.
Yeah.
Like once I feel like once the kids are all back to school, fall hits, and then it goes so quickly with the holidays. And so now is the time, right? We're seeing this motions hearing today, and I would imagine there would be more. Are there any more motions that you're aware of that might be coming down the pike, or anybody's alluded to in your discussions with the attorneys?
It was briefly brought up again today. There's been so many discovery issues in this case. If you look at the file, the defense is repeatedly compelling discovery, claiming the prosecutor has not turned over quite a bit of the evidence, and we're nearing trial. So I think we'll see more of that coming ahead because it was mentioned again this morning.
Such a good prediction. Chanley Painter in the studio with us this week. Thank you so much for all of that. Here's what we're going to do now.
Glad
We're
to have
going
you back.
to take, thank you, sweet friend.